You're listening to Members of the Jury, the show that takes you straight into the trenches of justice, where the passion, players, and consequences are real. Each episode, we examine current events happening in the system. From the battles in courtrooms to the streets demanding reform, we bring those stories here to you, the members of the jury, because we aren't afraid to take it to the box.
What's going on, members of the jury? As always, happy Freedom Friday. I am so excited to continue to be here as we are starting off the process of recording season 3. If you had asked me back in 2020 when I started this project if I thought that I would still be here and continuing to do this, I wouldn't have been able to confidently say yes. But after 3 long years of doing this, I could say that I couldn't imagine myself not doing this anymore. The amount of people that I've been able to connect with, the education that I've learned, and just the overall experience that I've gathered from this community has been absolutely phenomenal. And today, I'm so excited that we're continuing to reach across the country to different public defenders and private attorneys and criminal justice activists to share in this common message. Today, we have a outstanding trial breakdown. And joining us all the way from Maryland is Deputy Public Defender Matthew. And I do have to give a trigger warning on this particular episode, especially as a newly minted father, is that this does involve a shaken baby allegation. And so if those might be difficult facts for someone to digest, you might want to check out one of our other episodes. But Matthew, please introduce yourself to the members of the jury.
Thank you, Locust. Thank you for having me. I'm an assistant public defender in the state of Maryland. Maryland is a statewide public defender operation. There is a public defender for the state, and then there are, I think, 11 districts, and the districts encompass 1 or 2 counties throughout the state. This is my 3rd career. As I've mentioned, all my friends and all my associates know, I worked in professional theater in my 20s and early 30s. I worked in the airline industry in my 30s and 40s. And I was fortunate. I went back to school in my 40s, and I graduated law school when I was 47 years old, took the bar, and I've been a public defender for the last 15 years. So I have unlike many of my colleagues, I have a unique viewpoint in that I have not been a lawyer my whole life. I have not gone to school and then immediately become a lawyer. I do want to do one shout out to my cousin, Amy. I have one cousin who's a lawyer, and she is also a public defender in Louisville, Kentucky. And she's got a tough job because she does death penalty cases. And here in Maryland, we don't do death penalty. So I give a shout out to my cousin, Amy Hannah Brown, who's a public defender in Louisville.
Wow. Oh, well, we would absolutely, maybe offline we can connect, because I would love to, speak to her again and continue to connect with other public defenders, especially
Right.
On those caliber of cases. California is in a weird state where, we do have the death penalty, but it doesn't, there's that memorandum where it's not being enforced.
That's right.
But because we still do those trials, it requires the same, certification and training and prep as if, because one day that memorandum could get lifted and then we have that process. So that's awesome. And, the fact that you had that PD in the family, just, again, I always advocate how strong our beliefs in our PD family is. And, the fact that that's blended over into your immediate family is really powerful. Matthew had mentioned that he's been a public defender for over 15 years. And in that process, he's done over 50 jury trials, from drug cases to murders.
I've also done criminal contempt, which in Maryland is about guys who haven't paid their child support and wanted to go to trial over that. And I don't know why, but they do occasionally. And I've done those trials as well.
And in the craziest space, I could imagine that those clients are actually even more difficult than our clients as public defenders.
They're very difficult. They're very difficult.
Well, I can only imagine the amount of knowledge and hopefully trial nuggets we gain from you during this trial breakdown. So why don't you go ahead and let's get into it. Why don't you tell us what kind of charges was your client facing, and what was the motivating factor that led this case to ultimately go to the box?
This is a as Lucas said, this is a shaken baby case. My client was charged with one sole count of first-degree child abuse, which in retrospect was probably a mistake by the prosecutor, because when presented with to the jury with only one count, they had nothing to fall back on. All I had to convince them was that it wasn't this. They didn't have, there could have been a misdemeanor assault charge. There could have been a felony assault charge, but the prosecutor didn't charge any of those things. So I had that going for me from the start.
Yeah, I have to say that's a rarity to begin with. We continuously see in our profession the overcharging of complaints. That's just correct. To over leverage and pressure plea deals, or even the threat of, if you go to trial, we'll add more charges. So
that's right.
In this sense, in a weird way, I could see why you consider that leverage for you. That is just one or all or nothing.
I don't know if I'm unique about it, but my client always decides. And I know that everybody says, oh, the client decides, but my client decides. I'll give the client advice. I'll give them counsel. I'll even make the devil's argument for them. But I always make sure that the client is making the decision. And in this case, his decision was strictly, I didn't do this. I'm not going to plead out to something I didn't do. And so that's where we were. There was one advantage to this, and I actually didn't tell you. He was never incarcerated pretrial on this. So now, because it happened during COVID, that was one of the reasons he didn't go into the local jail and sit for almost 2 years waiting for the trial in this matter, which was fortunate for him. If you don't mind, I'll do a quick fact pattern of this case.
Yeah, please.
My client worked in a large city. He worked near Washington, D.C. at a hotel, and he was the night auditor. His wife worked for a government agency, and she worked 9 to 5, and it was COVID, so she was working from home with their 3 children. And he would come home in the morning at about 7 or 8 in the morning, and they would do their morning routine, and then he would kind of watch the kids while she did work online, as many of us did during that period of 2020 when many offices were closed. And he would kind of drift in and out of sleep, and the kids were aged 8. One of them was 9 years old at the time. The other one was about 3, and the other one was about a year. And so this particular day, he comes home, and he tells me that the baby, the 1-year-old, is being very fussy, and his wife was going to take the older kid to an assessment test at the school. It had to be done in person. So she takes the kid to an assessment test, and the school's only 5 minutes away, and she drives and then doesn't come home. The test is going to take, they told her, anywhere from an hour to an hour and a half. So she doesn't come home. She just sits in the car for an hour waiting outside. While this is happening, the 1-year-old kind of throws up, and it's all orange. And my client says it's a very unusual color. It's not something he sees. He didn't know what the kid had eaten, so he calls his wife and says, the baby just threw up. And she says, well, rinse him off in the tub. So he goes and he starts to rinse off the baby in the tub, and he says that the child all of a sudden goes limp, completely limp in his hand. Well, he doesn't know what to do. He calls his wife again, and she says, well, call 911, you moron. So he calls 911, and the wife also calls 911. Within 10 minutes, EMS arrives. They do a quick exam of the baby. There's no particular trauma that they can see, but the child is limp, so they decide to airlift him to Baltimore Shock Trauma, which is the best equipped center for this. And the mother travels with the child in the airlift, and our client drives his car to Baltimore. The child is examined. A whole series of tests are done, and over the course of about 18 hours to 36 hours, the doctors all conclude, based on CT scans, MRIs, optical and ophthalmological exams, all of these things, they conclude the only cause, since there is no apparent trauma, the trauma must be subdural, and it's all they see it all in the MRI, and they conclude that it can only be shaken baby. And so once they tell this to the police start interviewing my client and his wife, and they both deny anything. My client says, no, I didn't do anything. I did this. He never at any time said he did anything wrong. He did. The officers talked to her, and she told them, well, he does have diabetes, and he did pass out once, so maybe he doesn't remember doing something. All of a sudden, the police go, well, he must have passed out and shaken the baby without knowing it. And so they come back at him and start questioning him, saying, well, now, is it possible you passed out and that you shook the baby? And he goes, I don't know. If I passed out, how would I know what I did? And they go, oh, so it's possible that you shook the baby while you were passed out. And once they latched onto that, that became their theory of the case all along, in that he must have done it because he can't account for the fact that he might have passed out. So that's the basis.
Okay, so I have a couple questions.
Yeah, go ahead.
So did the child end up surviving, or did it pass away?
So the child is still alive.
Okay.
The child is now 3 years old, but has the mental capacity of a 3-month-old.
Wow.
This child suffered severe brain damage. It's a very sad case. The child, as I said, is now actually 4 years old now. Cannot do anything for itself. Will be this way for the rest of its life. The child is 4 or almost 4 and can't walk on his own. Is confined to a wheelchair. Must be fed. It's very, very sad. I mean, yes, the child lived, but the quality of life is very poor.
Absolutely. And so then I want to just take what we just digested in that breakdown of facts back to the complaint. And in this case, they left off the attempted murder even charges, right? It was just shaken baby in the aspect of it being an assault.
All it was child abuse, first degree. That was the only thing that was charged.
Okay. Now in Maryland, so in California, I could see that being filed as child abuse, but then having, like a GBI allegation on it to enhance the penalty and possibly make it a strike offense. Is that something that's in the Maryland system?
No. The closest thing would be when we run our sentencing guidelines, there is a vulnerability fact. And so if the victim is either under the age of, I think, 6 or over the age of 70 and is injured as the result of a personal attack of any kind, the sentence, you get extra points against you in the sentencing guidelines. And so it increases your guidelines. That would be about it.
Understood. Okay. And then even though we didn't necessarily go down the murder or attempted murder route, it sounds like there was a lot of expert personnel that ultimately got involved in this case, I'm assuming by way of doctors, medical examiners, and CPS. What was the discovery process like? Was it something that you had a lot of upfront, or was it something that you had to gradually get over time, especially with this case going to trial? I can only imagine it became voluminous.
Okay, so the front end, the police reports and the CPS reports all came very quickly. CPS didn't find any, they had no evidence of any, this client was not on their radar. There were no prior contacts with him. There was prior contact with her, with the oldest child, but that wasn't his child. So in fact, they had, as I said, they had 3 children. 2 of them they created through their union. And then there was the oldest child, which she had through another relationship. And there had been a CPS report that detailed her, that boy, and then that boy's father.
Got it.
And that was several years before. That's the only CPS involvement regarding any of her children. There was nothing on him. The police reports all came in very quickly and, immediately pointed to him and said, she's the paragon of virtue and there's nothing she could have possibly have done wrong. Regarding the medical, so we got the initial medical. So for example, we got the initial EMS report. And as I said, they went to Baltimore Shock Trauma, which is a state hospital, state-funded hospital. It's in downtown Baltimore, and that's where they do the airlifting. And then after a couple of days, the child was moved to Johns Hopkins, which is a very good hospital. And because it became, at least from reading between the lines, the doctors at Shock Trauma didn't feel comfortable working with this trauma. And so they asked to have it moved over to Hopkins because Hopkins was better suited. They had better doctors, they had better equipment. They were going to be in a better position to make any diagnoses regarding this. So they moved to Shock Trauma, and they did a whole slew of exams. And that was the thing that took the longest to get, especially, and for those of you who've ever done a shaken baby case, the thing they're looking for is retinal damage. And that's something that can only be done by an ophthalmologist. It's done by some particular, and I don't understand all of it. I'm a lawyer. What do I know? But it's a very detailed exam of the eye and of the back of the eye. And it's a telltale sign of shaken baby. This was the thing that we, in our office, it took us the longest to get. They didn't want to share that with us. And I don't know why, because when we handed it off to, in work product to our own doctor to look at it, he said, oh yeah, this is shaken baby. And that was the biggest problem, was that every piece of evidence collected medically, forensically, pointed to shaken baby. So it became clear from my own experts, that I would consult with. They told me, yeah, I can't come in here and discount any of it. I can discount a little of what they say, but not the overall and the overarching diagnosis. The overarching diagnosis is probably correct. This child did not get these injuries by falling off a bed. My client at one point told police that there was one day a couple weeks earlier where the two of them were, the child and my client, were lying on the bed, and the kid rolled off the bed, and my client reached over and grabbed him by the arm and yanked him back up on the bed before he hit the ground. And he said, well, maybe that caused, a whiplash of the neck that caused some of these injuries. That's what my client told the police. And the police said, oh, yeah. And the doctors all went, no, that wouldn't have done this. So there were a lot of things, and even my own consulting doctors said, no, this is shaken baby. There's no way around it.
Okay, so you go through the discovery process. You have an opportunity to see some of the things that their expert says, consult with your own, and it's the night before you're going to hear the prosecution's opening and give yours. What are your thoughts of your theme and theory of the case? What are you most concerned about as you're going into that trial?
So as we all know, and I wish I had brought the piece of paper. I have it sitting under my desk blotter. It's something I got from the National Criminal Defense Lawyers Association a number of years ago at a conference. And the thing is, there are 6 theories of every case, 6 possible theories. One is I didn't do it. One is I did it. Who cares? One of them is I did it, but it's not against the law. The other is I did it, but it's not against this law. I don't remember all of them. But basically, we were going with I didn't do it, period. And in long discussions with my client, it became clear that our best bet was to point out that in the 24-hour period between the time, in the 24-hour period directly before the child goes limp, look who was had the most care, custody, and control of this infant. And that became the theme that we would work on. Because if you go back the 24 hours, if you go back to about 11 o'clock the day before, my client is home from 11 until 7 at night. And then he's gone from 7 at night or 8 at night till 7 in the morning. Because he drives an hour each way to work. So he's gone for 9 or 10 hours. And the only person there is mom. And it's November of 2020. And mom's been stuck at home with 3 kids for months.
Overnight.
Months. Not overnight. Months.
Well, yeah.
Every day he gets to go out. Which one of them is going to become more frustrated with the child? And that's what our theme was. Who's at home and who's the more likely to get them frustrated?
Now, let me ask, was there a mixture of emotions between your client's feeling as far as I didn't do this and she did, or because I didn't, it had to be? There's the small line of differentiates thinking there, but I'm just curious.
Yeah. Their relationship was very peculiar to begin with. They met they had known of each other in high school, but they didn't know each other. Somehow they were at a common gathering and they were reacquainted and they met and they hooked up on their first date. She got pregnant on her first date. And when she told him that, he said, okay, and I'm not telling you anything privileged at this point. I'm telling you what he testified to. And he testified on the witness stand. He said basically, I always wanted to have children. If she was willing to have children with me, that was fine with me. Whether we loved each other was not as important. It was more important that she loved children and I loved children, and that together we could raise and love children. And so the prosecutor in closing said that my client only was interested in the mother as breeding stock, which was I thought it was way over the line. But unfortunately, the client kind of suggested that in his own testimony. So they had a very bizarre relationship to begin with. I'm not sure they ever loved each other. To go back to your question, he was not at all uncomfortable laying this off on her, saying she must have done it. Not I wasn't there, so it might have been her. But he was absolutely, I didn't do it, so she must have done it, period. And that's where he was.
Okay. So I want to have the opening statements broken down then. And, you said something really interesting right there about how basically the prosecutor in her closing more or less commented on how your client had testified. But I was wondering if she basically had that same kind of original theory that he just saw her as a child bearer in her opening. If she didn't have that information, what was her focus then when she started the trial?
She kind of did have that, but she didn't focus on it. She was focusing more on the fact that she was trying to make the case that he was not totally credible with the police. And she tried to say he was changing his story all the time, but he never changed his story. The people who changed their story was the police, who changed their interviews with the client. They would say they went to him one time and they would ask him one question, he would answer it. They would go to him another time. They would ask him a different question. He would answer that one. And then they would say, you've changed your story. And he kept saying, no, you asked me a different question. But in the opening, the prosecutor basically said, there's only one person who could have done this. He was alone with the child for the 2.5 hours that the mother left. Therefore, he's the only one who could have done it. That was the state's case. That was sum and substance in a ball. That's where they started with the case. Ours was, he didn't do it. And as a matter of fact, he wasn't home. And we said, we believe the doctors will support this. The state's doctors will support this argument when they testify.
Well, looking forward to see how, I think that's always some of the most impactful evidence you can have is when you're able to use the state's evidence or witness to your, case. And so we're really, why don't we go there, basically. So after the openings, the prosecutions begin their case in chief.
It's all, in a case like this, it's all about the police and how they respond and all this. And all of that is, nobody's disputing anything. I don't really care because there's nothing there. The key is, in fact, the doctors. And there were 3 doctors. One was the emergency room doctor. One was the ophthalmologist who did the study of the eyes. And the third was the internist who was the attending physician. And all 3 of them agreed that, number 1, we cannot tell you when this occurred. Number 2, we can't even tell you if it happened within the last 24 hours. And number 3, and this was the surprise, they discovered older bruising on the brain. Now, they couldn't tell me when it occurred, but there were bruises there that were older than the 24 or 48 hours directly before this, indicating that the child had suffered some kind of trauma before this one. And this was news to everybody.
How do you feel the prosecution then explained that or dealt with that information?
She didn't deal with it well. She was not happy. She thought that she thought that she had him cold. And I asked the simple question of, doctor, what day were these? Tell me what day the retinal bleeding started. He said, I can't tell you that. I said, well, did it start in the 2-hour period before 11 o'clock on the day in question? He said, well, it's possible. Is it possible the bleeding occurred 6 hours before? Yes, that's possible. How about 10 hours before? Absolutely, that's possible. How about 24 hours before? Is it possible it happened 24 hours before? Yes, it's definitely possible the bleeding started 24 hours before. Can you say when it started? No, but I can't narrow it down any closer than that. And all of a sudden, once you've narrowed it, said it's within a 24-hour period, now we turn back around and we point out, and I know I asked I asked, doctor, can you tell me for certain that my client is the individual who inflicted this injury? No, I can't tell you that.
So then, in their case in chief, did the prosecution still basically rely on the mother and the detectives with this pass out theory?
Oh yeah. Oh yeah. Oh yeah. Oh, mom got up there and wept and listen. I don't misunderstand. She has a tough road to hoe because immediately after charging my client, she had a protective order issued, obviously against him, and he's not been able to see the children since, to the best of my knowledge. He even asked me how to go about getting the protective order lifted, and I said, why do you want to do that? I understand you want to see these children, but she's going to be hell. And I said, you should go talk to a private attorney about this, not me, because I don't think you should ever have any contact with her again. He said, but my boys. I said, I understand that, but you need to wait a while. He was asking me this like the day of the verdict.
Yeah.
And I said, you need to wait no matter what you do. But she got up on the witness stand and she was wailing and crying and accusing him of being the devil incarnate. And the state just, was feeding her all of that. And she didn't like answering any of my questions. Like, by the way, did you feel frustrated being stuck at home with 3 children for the last 4 months? No, I love my children. Of course you do. I'm not saying you don't love them, but did you ever feel frustrated? Well, of course. Oh, did you ever act out with your children? No, I wouldn't. Did you ever grab your children roughly? No, I know, and in the end, we all know that as parents, children frustrate us. That's their job, basically.
Absolutely.
So it was difficult.
Let me ask you this. Was there, aside from the medical information, was there anything that the prosecution was able to elicit that, gave you a nervous feeling as to, how they might use that in closing, or just another kind of bad fact outside of the medical stuff?
Okay, so I have a theory. You don't go to trial unless, for 2 reasons. Number one, the defense or the defendant and the state cannot reach an agreement. That's one reason you go to trial. And the second is because it's a toss-up. It's a total toss-up on the facts, and you don't know how to read it. And so in this case, yeah, I was uncomfortable the whole time because I'm not going to sit here and say that I knew this was a slam dunk not guilty. I knew that the facts supported my argument, but that doesn't mean that the jury wasn't going to feel sympathy for the mother, that the jury wasn't going to feel sympathy for this child. So no, yeah, everything made me a little nervous.
And honestly, I think that type of, quite frankly, humility is something that distinguishes, criminal defense and public defenders, quite frankly, from prosecutors, because I don't think you would ever hear a public defender or criminal defense attorney say, we have a slam dunk not guilty. Like that type of verbiage and phrase just doesn't exist, where, you have these prosecutors who go around and try to say they have slam dunk cases only to then lose that trial. So
I had a slam dunk case 2 weeks ago. The prosecutor literally was walking around saying this is a slam dunk, again, on a felony child abuse, same prosecutor, and I beat her on the child abuse. I lost that on a misdemeanor assault, but I beat her on the felony child abuse. And she literally walked around saying, this is a slam dunk. I don't understand why this trial is scheduled for more than one day.
Oh, I hate when they say, "Why are we here?" Too. But that if we go down that, that's a whole nother tangent. So, what?
Same prosecutor.
And you would act like they, I'm sure she thought this was a slam dunk, and it somehow, they don't lose their lessons despite losing these slam dunk cases. And it's like,
I've been having a philosophical conversation with one of the deputies in the prosecutor's office, saying there's no way public defenders should ever win cases.
Right.
We should never go to trial and win, because if so, that means the state, number one, they failed to make their case to 12 uninvolved individuals, and number two, they didn't make any effort to try and reach a reasonable conclusion to this.
I love that.
I do hold three exceptions, and the three exceptions would be rape, murder, and kidnapping. Those are the three that should always go to trial regardless. But anything else, why the hell are you going to trial with this case? If you don't win, that means you, as a prosecutor, really screwed up.
Yeah, no, I agree. Either the police didn't do their job right, the prosecutor didn't do their job right, or the judge somehow didn't. And, that's why we're there. So I couldn't agree more with you.
Yeah.
Before we get to the second half of the trial, was there anything else that you thought maybe you took as solid victories from your cross-examination? I know you said that you were able to really confirm a lot of the medical evidence. Did you feel like you really just discredited the mother or any of the officers?
I didn't. The officers I didn't care about, because the officers didn't witness the crime. They're a nothing burger to me. I don't care about them. The mother, I don't know that I discredited her as much as was able to highlight that she was not a disinterested party and that she was biased against my client. That was the most important thing. I was very, very pleased that I was able to get the doctors basically on my side. When I finished with the doctors that way, I was gleeful in the middle of a trial because I had gotten them to say things that I don't think the prosecutor thought they were going to say.
And I think the best analogy for that is to equate that to someone in sports who's like in the zone. For a defense attorney to feel gleeful in trial, that's got to be fantastic.
Yeah, it was. Yeah, and then I went to bed and I woke up the next day miserable. So.
Of course, that's the trial process for you. Do you guys, or in this case, did you make a motion for a directed verdict at that point after the prosecution?
Yeah, we always. Yeah, in Maryland, there's a motion for judgment of acquittal. It's rare that anything is ever granted. I've had it granted once in one case, on a lesser charge that the prosecutor never addressed. So that's easy. But yeah, it's the response from the judge is always, I believe that enough evidence has been elicited from the testimony and the evidence for a jury to reach a verdict.
Right.
In the light most favorable to the state.
Okay, so that takes us about halfway through the trial. I always like to take this little aspect as an intermission in the podcast to remind all of the listeners that if you have any interest in being a guest on the show or know anybody who would like to be a guest on the show, please have them reach out to me at lhursty@membersofthejurypod.com. You can also find us on social media, YouTube, Twitter, TikTok, and Facebook. I would love to connect with you, share your story, or advocate for a better criminal justice system. Matthew, so we're in your case now. The prosecution have put on their best foot forward, and we always come to the rare aspect of a defense case in chief. And I think you had alluded to it a little bit earlier in that your client testified. So I know you at least put on one witness. Aside from him, was there any other components of the defense's case in chief, or was it pretty much all eyes on client?
No, it was all eyes on the client. And the client, you talk to a client, and I had an advantage. This client had no history in the courts. He had no history with CPS, so he had nothing impeachable. So the danger was just his testimony, and he and I prepared it. And, he was very flat in his presentation, which the prosecutor made note of in her closing, saying, just look, he has no emotion whatsoever. He's a robot, for goodness sake. But he was a very flat individual, but he told his story. And, he said things that were uncomfortable about his relationship with his wife, about the way their married life was. But, I think helped because it was honest. I think it would help because it showed the jury that he had nothing to hide. And, he told his side of the story. He told the night before he went to work. He worked all night. He came back. He did this. He did this. He called 911. I have no idea how this happened. I even asked him if he thought she could have done it. He said, no, I don't think she could have done it. Now, after he testified, he did say, I probably answered that question wrong. I said, no, you answered it honestly, and that's what the jury wants to see.
Yeah, and that relates back to our previous question, kind of like I was kind of going for, and I think that to me gives me a really solid answer as to where he stood in that, and it's like, to me, it's that philosophy of like wanting to succeed because you're great, not because someone else had failed. And, here it sounds like, he really wanted his name cleared and his justice because that was the truth, not at the demise of and falsely and putting blame on her. So
that's right.
I actually think that you summarized that really great, that was a truthful answer. And I think those are the best answers to jurors. You know what I mean? Like authentic is what you always hear from members of the jury about credibility. Right. So if that was a moment that they saw of him having authenticity, whereas, she might have lacked, maybe right there is your case.
Well, and he didn't show bias against her. I think I didn't talk to any of the jurors because I'll tell you when we get there, but I didn't talk to any of the jurors. But I think part of that goes to, he did not express bias against his wife, whereas she expressed bias against him. And so if you're in the jury room trying to figure it out, well, go with the guy who at least seemed not to have an agenda.
Right.
She had an agenda. She wanted him prosecuted.
I mean, because at the end of the day, they both now have a child who was injured and
that's
suffered.
Right.
So I think that's some great
that's
insight.
Right.
And like I told you at the beginning, I'm sure that with your vast years of experience and your voluminous trials, that we would get some nuggets through this episode, and there's definitely one right there. So I think that that's a great insight into breaking down witnesses and speaking to the members of the jury as to how bias can play a role. I actually think that's a great segue into the, well, let me ask you this. How did you feel your client held up against cross-examination? Because I think that when our clients take the stand, because we have an opportunity to not necessarily rehearse and coach them on direct, but have that opportunity to have that discussion with them about that process. But very rarely do they get to go through a simulated cross-examination. So that's always the scary part. How do you feel that went for your client?
So again, as I said, he was flat. One of the things like many lawyers do, I tell them, make sure you answer the question that's asked. Don't just rattle off what you think the response is. I always tell them, take a second, replay the question in your head, and then answer the question. The prosecutor wants to ask questions in a rapid-fire way to get you to answer the wrong question incorrectly. But as I point out, I say they want to set a pace. All you have to do is slow down, and all of a sudden you're setting the pace, and now you're disrupting their whole presentation. That's the first thing I try and do. In this particular case, she tried to get him to admit that somehow he lost control or that he blacked out and could have done this. And his response in time was he said, when I was talking to the police, I really wasn't thinking about it. In the time between talking to the police and today that I'm testifying, I can tell you, I don't remember ever blacking out, and this is all crap. The one thing the wife had testified to was that one day, several years before, maybe months before, they were lying on the bed, and all of a sudden he was sleeping and he was kicking his feet, and he kicked one of their pets, the cat, off the bed. And she woke him up and said, well, what's going on? And he said, I was dreaming about a bear or something. And she said, well, you kicked the cat. He said, oh, okay. Well, and he rolled over and went back to sleep. Well, she told the police that he had blacked out and kicked the cat. And when police brought this to him, he said, I don't remember blacking out and kicking the cat. I don't. And they said, well, your wife told us this happened. He said, no, I was sleeping. Aha. So you were not conscious and you kicked the cat. Is that what you're telling us now? And I even asked the cops about this, and they on the witness stand, and they said, Well, we found out that he was sleeping, not blacked out. Oh, okay.
Did they find out whether or not the cat lost one of its 9 lives? That's the real
No, they did not do any follow-up on the cat.
That's why luckily he didn't have a count too.
Right. So, or no animal cruelty.
Right.
Animal cruelty. I guess they could have gone there.
Right.
So the answer is, going back to your question, how did he do? He did fine. He was not a, he wasn't a great witness, but he was fine. And he stood his ground against the prosecutor. And the prosecutor actually became frustrated with him because he wasn't answering quickly. And because he was doing a good job of answering, she would ask, yes or no questions, and he would only answer yes or no and not go into the detail.
Well, good. Okay, so take us to the closings. Were there any persuasive arguments that the prosecutor made during their closing that you felt like you had to address, or were you pretty much just focusing on the facts that you were able to elicit during the trial?
I will tell you, it's been, 4 or 5 months. I don't remember exactly. I've done 3 trials since then. I will tell you, though, that there was something that came into my head on this particular trial that I've now used on all of my trials. And I get a big piece of white paper, and I write maybe equals, and then I write the word guilty, and I put a red circle with a line through it. And so it'll say maybe equals not guilty, possibly equals not guilty, probably equals not guilty. And I went through that with all basically saying, ladies and gentlemen, I don't know what you think happened. I wasn't there. You weren't there. The prosecutor wasn't there. The police wasn't there. Maybe he did it. If you think maybe he did it, the problem is it's still a not guilty. And I've used that now multiple times. And I don't know, I'm sure I'm not the first person to come up with this idea. But I think it can be effective because it counters effectively. I think it counters effectively. The prosecutors are always saying, well, you must find him guilty because all the evidence points that way. And they just leave it out there as if it's a fait accompli, but in fact it's not. And I think it's important that defense attorneys point out that the law says you are not guilty until all of the elements have been proven beyond a reasonable doubt. And therefore, even if you think possibly he did it, but you're not quite sure, then it's a not guilty. And I think that has to be reinforced with a jury. And I think in my case, it helped in this particular matter.
I absolutely love that as well. That's a slide that I end all of my trials with as well, because what I think, I know that each state kind of defines what is reasonable doubt somewhat differently, but at the end of the day, beyond reasonable doubt is not a common measurement in which people make decisions. It's the maybes, it's the possiblies, it's the somewhat.
I'm sure everybody who's listening who has ever tried a case, at one point in their career when they've done a trial, the jury will come back with a note, and the note will say, can you define reasonable doubt? And inevitably, the judges, or, in our case, the judges usually say, we gave you a written instruction, what's called the pattern jury instruction in Maryland. We gave you the pattern instruction of what it says. That's what you use. We're not going to define it any more than that.
That's so interesting. Were there any jury notes in this case?
Not that I recall.
Okay.
I seem to recall it was about 4 hours, which I thought was a good amount of time. It means that they reviewed, to me, I don't know what the hell they were doing, but it suggests to me that they reviewed the evidence fairly and adequately. I'm glad it wasn't, to a certain, on a case like this, I would have rather really had it been 7 minutes with a not guilty, but I'm fine with the fact that it took them 3 or 4 hours to talk about it and to come to the conclusion. I will tell you that when they came out and they sat in the jury box and they announced not guilty, but there was nothing. I had written on a piece of paper. I just had my yellow legal pad in front of me, and I just wrote NG, circled it, and it's sitting on my door at work.
That's right, baby.
And that's all there is on the piece of paper. Not even the client's name. I was just, it's just a piece of paper. Normally,
that's all you need,
because there was only one count. Now, if it's a multi-count thing, I have all the counts lined up and I write it down. But it was the one thing, and I just wrote not guilty.
Yeah.
The guy sent me an email about a week later, and I meant to bring it and I forgot it. And what it said was, it says, "Thank you for your help. You saved my life."
Absolutely.
And that's the most heartfelt thing any client has ever said to me. I've helped a lot of people, and a lot of them said, "Well, you've helped me a lot," but I've never had anybody say, "You saved my life." And I sent back. I said I was glad to do it.
They tell you early on in this career that it's a thankless job. So not only to get a thank you, but for someone to understand the magnitude in which your lawyering did accomplish is definitely no paid attorney. Well, I mean, no amount of money could justify that feeling. I mean, private attorneys, I'm sure, get that same feeling when they win their cases. But yeah, that's fantastic.
Yeah, absolutely.
Matthew, what a great experience. We're so thankful that you broke down that trial and gave us those little nuggets for future trials that you do, that I do, or any of our audience members do. We always end the show with one last final question, and that's, what is the significance of taking matters to the box?
It has to be the client's decision. We can't go to trial because we think it's a winnable case. We have to go to trial because the client understands the dangers and the potential benefits of going to trial. And so in this case, my client, he had no intention of ever pleading guilty to something. And since there were no lower counts, there was nowhere to go either. So that kind of, in the long run, that helped me more than anything else, as I said, because the prosecutor screwed up. They should have tacked on 1 or 2 or 3 or 10 other counts so that they might be able to get something out of it. And by only charging 1 felony count, they got nothing out of it. And this guy's life is forever changed.
Amen to that. Well, Matt, thank you again so much. We really appreciate you coming on the show, and we wish you all the future success in your future trials. Well, members of the jury, that's our show, and I rest my case. Be sure to come back next episode as we take another matter to the box. If you're a fan of the show, go ahead and subscribe. You can also find us on social media at Members of the Jury. If you want to be a guest or have any feedback, be sure to email us at lhursty@membersofthejurypod.com. The information in this podcast is provided as general reference work as a public service. The audience is advised to check for changes to current laws and to consult with a qualified attorney on any legal issue. The use of this material does not create an attorney-client privilege in any fashion with the podcast, the host, or the guest. This information is for educational purposes only, and no one affiliated with the podcast may be held liable for any decision made based on this information.